Hello and welcome back to my channel. In part one of this series, we talked about having crippling debt while living on low income as a senior or with a disability. We talked about how to stop phone calls and letters from creditors, and I included a letter template to send to your creditors. We also talked about two solutions for handling the debt: bankruptcy and debt settlement. Now let's talk about another solution. So the debt is still out there and you don't think bankruptcy or debt settlement is for you. But then a knock comes at the door and someone serves you with a summons for a lawsuit a debt collector filed. Questions fill your mind. Do you have to hire an attorney? Will you have to go to court? Will they take your money and your belongings? Take a deep breath and don't panic. Listen closely to what I have to say. The people I'm addressing in these videos are seniors living on just Social Security or a pension, and disabled persons living on Social Security disability or veterans disability. And just like there are laws that protect you from receiving harassing phone calls, there are laws that protect your income and assets. Any federally protected income like Social Security and disability is protected from garnishment. And it's not just the amount you receive monthly. 2 times your federal benefit is protected from garnishment from your bank account. So if your Social Security is $1,500 per month, $3,000 in your bank account is protected from garnishment. Even if a collector files a lawsuit, unless you have more than $3,000 in your account, there's nothing they can take. If you have more than that in your bank account, that excess could be held up, but only temporarily. You could file what is called a challenge of garnishment or claim of exception to have that balance released. When your only source of income is protected from garnishment, you are considered judgment proof. That means they can file a lawsuit and get a judgment against you, but they can't collect on that judgment. Now, what if you have assets? If you have a lot of assets, like bank accounts or other valuable tangible assets, then you are likely not judgment proof. In that case, you can still stop phone calls and letters, but you should contact an attorney to see what alternatives there are for you. But back to the people I'm really talking to you. Those of you who own very little and whose income is protected. Even if you have some assets, every state has exemption laws that protect a certain amount of your assets. In my state, that amount is $6,000. But what if you own a home? If the creditor gets a judgment against you, state homestead laws prohibits them from taking that asset. For example, Eric Olson of Helps nonprofit law firm recently shared that in Texas, a home plus the 10 acres it was on was protected no matter what it was worth. The amount of the homestead exemption depends on which state you're living in. However, Eric also shares that it is not the practice of a creditor to go after someone's home to pay a consumer debt, even if you have equity in the house over the amount of the homestead exemption. Maybe you don't own a home, so you aren't worried about that. But you do have a car, and you need to be able to get around. Well, if you have a loan on your car, you will have to pay that debt if you want to keep the car. But what if you own your car free and clear? As I explained earlier, your state will have an exemption law that will protect a certain amount of your property, including your car, your furniture, etc. There's very little value in furniture, and collectors know this, so they do not go after someone's furniture. Even if your car's value is above the exemption amount, it is a very complicated process for a creditor to try to take the car. Eric Olson says he can only recall 2 times when a creditor actually went after a person's personal property. A general judgment creditor, like a credit card company, has to go through an entirely different court procedure to do that. It's costly and it's typically not worth it for them to do that. So now you know that even if a lawsuit is filed against you, if your income is federally protected and you have few assets, you are judgment proof. But the lawsuit still exists. What happens now? Let's talk about the legal process going forward and also about bank garnishment. You now have the knowledge that your income is protected, and that knowledge is power. But even if your creditor knows that the only income you have is federally protected and that you have little to no assets, they may still file a lawsuit, and it's their right to do so. If you've never had a lawsuit filed against you, it can be intimidating. If you've been served, what you've received is a summons and a complaint. The summons will tell you that you must file an answer within a certain number of days. Do you really need to file an answer? Well, the only reason you need to file an answer is if, for some reason, you don't believe you owe the debt. If you want to fight the validity of the debt, then you should speak with an attorney. If, however, you agree, yep, that's my debt, all right, then you don't need to file an answer. It's up to you whether you want to go to court. You could go to court and tell the judge that yes, you owe the debt, but you can't afford to pay it. A judgment will still probably be issued against you. The outcome would be exactly the same if you did not go to court. The creditor will ask for a default judgment, meaning that since you didn't show up, the court will default in their favor, and the court will grant it, and a judgment will be issued against you. It's the exact same result, but it saves you from having to go through the stress of going to court. So what happens after a judgment is entered? It's possible nothing will happen. You'll have a judgment entered against you, and it will stay on the court records, and that will be the end of it. It should be noted here that judgments do not appear on your credit report. The only way a potential creditor would know that there's a judgment against you is if they search public records. For example, mortgage loan companies will search public records, and if you have a judgment, it will affect your ability to qualify for a loan. Another scenario is that the creditor may try to garnish your bank account. Now remember, 2 times your income is federally protected from garnishment. The creditor may send a garnishment notice to your bank. If that happens, there are legal departments in banks that handle garnishments. They should understand the law regarding protected income. Once they receive the garnishment notice, they have 2 days to review all of your accounts as well as the source of funds in your account. They will see that the source of funds are from a protected source, and if your bank balance is less than twice the amount deposited each month, they will disregard the garnishment. During this 2-day review, it's possible you may see your bank account has been frozen. If it's been less than 48 hours, don't panic. Your bank has finished the review, then they will release the funds. If you didn't get a copy of the garnishment order, you can ask your bank for a copy so you can review it. We've covered this whole idea of being judgment proof, but I'm guessing there are some of you out there thinking, I incurred this debt and I should pay it back. I honor my obligations. I would feel guilty if I didn't pay it back. I completely understand that sentiment. But please remember that life doesn't always follow the path we intended. Remember how many people lost their retirement accounts in 2008 and never recovered those funds? Currently, we are going through some pretty high inflation. Maybe you are carefully planning things and you thought your retirement funds would be enough, but an illness, the death of a spouse, or any number of unexpected situations can have you run through your funds pretty quickly. For some people, illness or injury forced them to retire before they even had a chance to plan, and they didn't have a chance to pay off debts and maybe even incurred additional debt with medical bills. As a result, you're left with some pretty unpleasant decisions. But having to make a choice between basic needs and debt should not be a cause for guilt. No one wants the elderly or disabled to suffer, and that's why the laws we talked about were put in place to protect your income. If you've watched the videos in this series to their conclusion, you may still be feeling overwhelmed. You may feel like you just do not have what it takes to deal with all of this, and you don't trust that you know enough to handle it on your own. It is a lot to absorb, and none of it is easy. At the beginning of each video in this series, I included a disclaimer that I am not a financial professional or a lawyer. What I have presented here is information that I have obtained after many years working as a paralegal. And in my search for knowledge regarding this matter, I found a wonderful resource that I would like to share with you. Earlier, I mentioned Eric Olson of Helps nonprofit law firm. Helps law firm works with seniors and disabled persons who are struggling with debt. They do not help with bankruptcy, and they aren't a debt management company. What they do is represent clients with unwanted debt collection communications. They can talk to your creditors on your behalf. They will be the ones who will talk to the lawyers if a lawsuit is filed. They won't represent you in court, but they will help with every other part of the process. If you have questions, you can call them multiple times a day. They will walk you through everything to help take away the stress. And remember when we were talking about someone who might want to improve their credit score? When you've been enrolled in HELPS for more than 90 days, they can enroll you in a course called 7 Steps to a 720 Credit Score. HELPS will enroll you in that course at no cost to you. If you want more information about HELPS, I think the best way to start is join in one of Eric's live broadcasts on YouTube, which air every Tuesday and Thursday. You can join the chat, ask questions, and get answers directly from Eric. This is not any kind of paid endorsement. I receive nothing for sharing this information with you. When I came across HELPS, I found Eric to be knowledgeable and approachable. HELPS is a 501c3 charitable organization. They don't turn anyone away. Their fees are based on your ability to pay. I put the links for both the HELPS YouTube channel and their website in the description below. If you are a low-income senior or living on disability, you don't need to live with the stress and fear of debt every day. There are answers for you, and you are not alone.